Our next presentation, Apply for a Trademark, is going to be presented by Matt Schwab. Matt is a staff attorney for electronic filing and public web services here at USPTO. And I'll go ahead and turn over the presentation at this time to Matt. Thank you, Matt.
Okay. Thanks for that introduction, Sean. I'm going to just make sure I've got control of the PowerPoint. I do. All right. Again, thanks for the introduction. My name is Matt Schwab. I'm a trademark attorney with electronic filing public web services. We develop legal policy for electronic filing. We oversee legal content for the website. We answer questions to the T's inbox, other customer service venues, and we also, and probably what you guys are all here for today, oversee and administer the T's online application system. So when you apply for a trademark, you have to come in through the Trademark electronic application system, and we're going to go through several different forms and different portions of forms today to give you an idea of what to expect. So without further ado, here's T's. So the second bullet point is something to note. It's going to be almost every single filing that you can do. And with the passing of a recent mandatory electronic filing rule, for 99.9% of you, it's going to be every single filing that you can file on a trademark. So it's not just the initial application. It's not just responses. It's not just maintenance filings. It's everything. So there's 3 ways to pay when you file through T's. You can use a credit card, you can use an electronic funds transfer, or you can set up a USPTO deposit account. Typically, this is more popular with our attorney customers, but anyone can do it if they go through and fill out the paperwork. The next thing we sometimes get asked is, where is this data used? So when you input information into a T's form, it's going to show up in a few different places. One of them is the Trademark Status and Document Retrieval site, or TSDR. You can see the URL there. And this is the public access portal to view all the documents that are associated with a file. Office actions, responses, maintenance filings, even examiner's amendments, notes to the file that may have been made in order to prosecute the file. All those things are going to be viewable, and they're all public. And this is going to go to one of the points that I'll mention a few times, is that when you file for a trademark, almost all of your information, with very few exceptions, is going to be public. So keep that in mind when you apply. And often, if you apply and you unintentionally include information that you did not want to be public, we can't remove it. There's only certain categories of information that we can remove, and it can sometimes be a high bar to meet. So just keep that in mind when you're applying. The information in your application will be viewable, and TSDR, with the exception of a domicile address, which I'll talk about later. Your information will also show up in the Trademark Electronic Search System, or TESS. Ideally, you want it to. So once you get your trademark, other people will see yours and realize that you had that idea first. And so they will be able to find your mark and not continue with their application. You can also use it, of course, to search the trademark database for other marks when you're getting ready to apply yourself. There we go. So what are some of the common forms? Oops, I think we skipped one here. I think I'm on a little bit of a delay from the screen. There we go. One of the things you need to know before you access T's is that you're going to have to log in with a USPTO.gov account. This has been a requirement for almost a year now, and it's the same login that you are required to do for EFS Web. So probably many of you are familiar with it. We require it for security. You can use your current USPTO.gov account. If you already have one, you don't need to make a new one. If you don't have one, you can make a new one in just a few minutes. And this is the sort of the office-wide login policy. More and more of our business units are going to use this in the future. So eventually the entire agency will use this to conduct business across all the different units, not just for patent filing and trademark filing, but payments and other systems that we use too. Now we'll get to those common forms. So when people think about applying for a trademark, they're thinking about the initial application form, right? How do I get this application in? That is a critical first step, but it is by far not the only step. And just as in patents, the initial application is the beginning of a long road. You may need to access a response form if an examiner sends you an office action. If you're not ready to show use at the time of application, then you might need to file some intent to use forms. That means you're going to show use later on in the process. So you may have an invention that you haven't started producing, but you want to secure your rights for the mark. You apply for the trademark, and then you say, I will use the mark soon. And you can file extensions on this in 6-month increments, but you're essentially saying, I understand that I won't be able to get a trademark registration until I show you that I am selling this to people or giving it to people or something. It exists in the marketplace. Here it is. And these are what the statement of use, the SOU extension request, the amendment to alleged use, this is what these are all getting towards. You weren't using it when you filed the application, but now you are. You can also use TEAS to file correspondence, power of attorney forms, basically record updates. And finally, after the mark registers, you can file registration, maintenance, and renewal forms. These have compelling names such as sections 7, 8, 9, and 15, and there are even some other sections in between there for the less common occasions. But these are sort of the big ones. For section 7 for making a correction to a registration. 8 and 9 are affidavits of use and renewal applications. So there are several different steps that you'll have to take even after you get the registration. So when you file, there are 2 different initial application forms. And these are TEAS Plus and TEAS Standard. So they have different requirements and fees. TEAS Plus is $225 currently. TEAS Standard is $275 currently. These prices are, of course, always reevaluated. They go both up and down, surprisingly. But these are the current prices for these applications. And this is on a per class basis. We'll talk a little later about what that means. Don't confuse this with the filing basis, which is something important that you'll need to decide when you apply. It's what gives you the right to apply and says that you're able to file this application and you believe it will mature toward registration. And we said that before, you have to either be using the mark, have an intent to use the mark, or you may have a foreign application or registration that you're going to rely on. There is another option, and you can use an international registration using the Madrid Protocol. That is not a common option taken by many independent inventors, and so we're not really going to discuss that deeply. It's in some ways a parallel system to the system through TEAS. It goes through a system called TEAS-I, and there's not much that carries over between the two. However, again, the vast majority of US-based or even foreign-based inventors are going to be applying through TEAS using one of the other bases. This is just a quick chart of some of the differences. You can see the price difference. And the main difference between TEAS Plus is you are restricted to what you can do. And the reason for the restrictions are to keep mistakes from being made in the application, which results in a faster, smoother process for everybody. So you're going to have to, the first 2 of these, everybody has to do, right? You don't have to give your email address now. That's part of the mandatory electronic filing requirement. And you also have to file your documents through TEAS, except in very limited exceptions when there's an outage, and those instructions are on the TEAS page of what to do if there is an outage. The third one is one of the major limitations of TEAS Plus. You must select your goods and services from the ID manual. This is one of the biggest roadblocks that people run into when they apply. And when you choose goods and services from the manual, you are assured that they are acceptable. Now, there may be some issues with them, and you still may receive an office action, but by and large, when you choose these things from the ID manual, the IDs themselves have been vetted and are acceptable. If you file TEAS Standard, you can use free text to type in exactly what it is that you think you're doing. This may be subject to further questioning from the examiner. You also do need to include certain statements in the initial application under TEAS Plus, a translation statement if you're using foreign wording or characters. You may need to include the claim of ownership of prior registrations, a color claim, and a description of the mark if you've got design elements, or the consent of someone whose appearance shows up in the mark or whose name appears in the mark. And so if you do not meet these requirements, it is an additional $125 per class filing through TEAS Plus. So depending on your needs, TEAS Plus may not be the less expensive option. If you're unable to meet these requirements, you will receive an office action and there will be an additional fee required. So depending on what you need, and we'll talk about this a little more, you may opt to use TEAS Standard for your application. And this slide just sort of goes through the TEAS Plus issues that I mentioned on the previous slide and indicates what will cause you to lose that status, right? You didn't file documents electronically. You didn't maintain a current email address. That means if we send you something and it bounces, if your email address is not receiving email, it's possibly grounds for falling off of TEAS Plus. Not always, but it's possible. And the name, portrait, and likeness of a living individual, deficiencies in the color description and color claim and a color mark. If your specimen just shows a very different mark than the one that you're applying for, or you don't have that translation or transliteration statement, if the foreign wording is in non-Latin characters, you need to transliterate it into a Latin phonetic equivalent. So there are some fatal filing errors. If you make these, it is usually not possible to recover from them, and the application is essentially discarded. It can't proceed. And unfortunately, there are no refunds because we still have to process these. So one of them is filing the wrong mark drawing. Please make absolutely sure that what you are submitting as the mark drawing is what you really want to apply for. You can make very minor changes to the drawing after the application, but generally anything major, you're not going to be able to change. So please be aware of that. Also, entering the wrong owner information. We're going to cover that a little bit when we look at the form. Sometimes you can correct this information, but if you put an application in the name of a wrong party and that party exists at the time of the application, it may void the entire application. We can only correct essentially mistakes, typos. I put the wrong state of incorporation for my business, and there is no other business with that state of incorporation in the same name. Things like that may be corrected, but many of them can't. And finally, choosing the wrong goods or services. These can be fatal to the application. If you believe that you're choosing the right thing, but it turns out that what you're choosing is not according to the USPTO, what you're actually doing, you may not have a recourse to adjust it. The reason for all of these fatal errors is that we rely on a public notice system. And that means, obviously, the same as patent, everyone is monitoring the trademark system. And they're looking at what's coming in, deciding whether they want to write a letter of protest, whether they may need to oppose, whether they want to write a cease and desist. And so when this information comes into the public record, it must be accurate, and we can't change it after the fact, or we wouldn't be serving proper public notice. That's why these are fatal. So let's take a look at a TEAS Plus application. When you go to teas.uspto.gov and you begin to apply, this is what you're going to see. This is the first part of the first page. And I'm going to just touch upon a few things on each of these pages here. The first thing that I just want to mention here is that, again, in bold, our fees are processing fees, and they're not contingent upon the successful prosecution of your application. If something is wrong, unfortunately, you can't refund it. It's good to also take a look at the screen and read it before you begin your application. One of the reasons is that the USPTO.gov account that you're logged in with will time out if you're inactive on a page for more than 30 minutes. So you generally need to have some sort of activity on a page every 30 minutes in order to keep the session active. So it's better not to, apparently the scroll bar also changes the page. It's good to know. But it is much more sensitive than the arrow keys. So, but again, read this before you start. Otherwise, going back and reading it later, it might take valuable time from your session. At the bottom of this page is where you're going to select the filing option. Again, this is not the filing basis. You're choosing either the TEAS Plus with the lower price per class, but the additional requirements that you must meet, or the TEAS Standard. And again, for number 2 is an attorney filing the application. We're going to proceed through the rest of this as though you have selected no. An attorney is not filing the application. Finally, at the bottom here, if you have saved an application, this is where you'll upload it. You can, when you get to the end of a form, and unfortunately only at the end of a form, at the validation screen, you'll have an option to save your progress if you're not ready to submit right at that moment. The progress will be saved in the form of a .obj file. This file will not open anything except perhaps an unintended program on your computer if you attempt just to open the file. The only way it's going to work is if you come into the TEAS form, act as though you're beginning a new application, and then browse for that object file and upload it here. Then it will load the information into your form. You'll need to re-sign and revalidate the information, but everything else should stay. So presuming we're moving on through the application, opting not to use an attorney, we'll get to the owner information page. Now, when I said earlier, one of the fatal mistakes you can make when filing an application is the owner information. This is particularly true for individuals who may be doing business as some other entity or may have a small company. Keep in mind, whatever you put in the owner of the mark field here is the legal owner. So on all the records and on the registration certificate, the entity that you put in there will be the owner. If you put your own name in, it is presumed that you as an individual own the mark. And if you're planning on using a corporation or LLC or something that you own to shield from certain liability, that won't be the case. So if you put your own name as the owner of the mark, you, the individual, are the owner. You can select in the box down below that you're doing business as or some other entity information. But if you intend, say, for example, you have a Virginia corporation, and you intend for your Virginia corporation to be the owner, put the corporation name as the owner of the mark, and then you can put DBA if you're doing business as some other name too. Otherwise, again, if you put your own name in the top, then you put your corporation name in the DBA, and then you say that the entity type is a corporation. This is probably, in this case, a correctable error. In some instances, it may not be. So please avoid it because you will have to talk to an attorney who will give you a complicated legal explanation depending on the facts and will not be the highlight of your day either way. So please just bear in mind, again, that owner of the mark has to match what's in the entity type field below. If you put an individual name in there, please put an individual checkbox down in that entity type. And on the next page, you'll see you'll have to provide citizenship, which does not affect your ability to file under the domicile rules. However, you will need to also put a mailing address, and this mailing address will affect your ability to file under the domicile rules. We have a rule that says foreign domiciled applicants must use a U.S. licensed attorney to apply. So you can be a foreign national as long as you have a U.S. address, and you can apply without using an attorney. If you are a U.S. national with a foreign address, you may need to prove your domicile or use an attorney. One way you can prove domicile, and also another way that you can use, for example, a P.O. box as your mailing address, is to use the domicile address field that has the checkbox in the middle of the page. Generally, we do not accept P.O. boxes or addresses that are not true business addresses if the entity owning the trademark is a business, or home addresses if the individual is the one applying. We do not accept addresses that don't map to those kinds of addresses as the mailing address unless there's a different domicile address provided, because we must, under the law, collect the domicile. This domicile address, if you put it in here, is not shown to the public. So for example, you could put a P.O. box in the mailing address and then your individual address in the domicile address field once you uncheck it. These will not show, the domicile field will not show up as part of the public record. However, in general, in order to streamline the application process and cut down on unnecessary office actions, when possible, your mailing address should be a street address, whether it corresponds to an individual or to a company. Generally, the domicile address should be used in limited circumstances. And finally, you can see that the email address is required. Again, please make sure to keep it current. On the next page is where you put your mark. We're going to proceed as though we're using a standard character mark. The standard character mark is just protection for the word. So here I have the word test that I typed into the field. This means I'm applying for a mark of the word test in virtually any configurations as long as it's recognizable as test. So I don't need to have my font picked out. I can change how I want to use it later. It's just protection for the word test as applied to the goods and services that I'll put in later. You can also click the radio button in the middle to choose to submit a special form. This is where if you have a logo or stylized wording or a special design, this is where you get protection for that mark. You can file applications for the same mark if one of them is for the wording in the mark and one of them is for the design version. They would be separate applications. So you would file once and then go through and file again for the second. One bit of warning here is at the end, I'll show you how to validate the information that you've put in. If you're using a standard character application form, whatever you put in as the mark is just going to show up as the word mark in the filing receipt that you get. Unfortunately, it's a system limitation. What happens is it takes the text, it makes a snapshot of it and turns it into a JPEG. And so the name for that JPEG is standard. It's just mark.jpg. So whatever you type in here is going to show up as mark in the filing receipt that you get. There will be a literal element field that actually has the wording that you typed in, and that's what your mark will be. So we often get questions about that. Like, why did I file for mark.jpg? I definitely did not put that in there. And that's just how it shows. Down below, there's an additional statement section of the form, and this is for several things that often are the subject of requirements or refusals by the office. You can see the list there. And again, many of them are TEAS Plus requirements. So if you're claiming prior registrations, if you need to translate or transliterate text, if you need to get consent from somebody whose likeness or name is in the mark, etc., you would click that box and fill out whatever parts of that field you need to fill out. It's going to open about a 2-page large form with everything in it. So you'll need to scroll through and fill out the relevant sections. We will proceed as though we don't need to do those things for this application and move on to the next page where we're going to pick out the goods and services. It's a TEAS Plus application, so I don't have the option to type in my own goods and services. I have to add them from the ID manual. So I'll click the Add Goods and Services button at the bottom, and the ID manual will load, and it looks like this. I typed in hammers, and it came back with 30 results. Now, please note the international class column at the left. This international class column is equivalent to a subgrouping of goods or services that are considered roughly similar. So here we have 30 results, and we have 5 different classes, 7, 8, 10, 15, and 28. And each one would have a different fee associated with it. So everything in Class 8 would be under one fee, the fee for Class 8. The claw hammers and the ice hammers, that would be $225 for this application. If you need to add hydraulic or air hammers to it, that would be adding another class, so another $225 fee. And here we can see we've got Class 7, the class for power tools, 8 is for hand tools, 10 is for medical goods, 15 is for musical instruments, and 28 is for toys, games, sporting equipment. So we've got quite a wide variety just by typing in hammers. So please note on the left how many classes you're selecting. You'll see on the next page it'll have a different entry per class, and it will make the fee breakdown clear. And finally on the right, the TM5 is not extremely important. That basically just means, is this in the set of IDs that's been accepted by the 5 largest trademark, I guess I should say, national entities or international entities, because it includes the EU as one of them. but as sort of the 5 major filing bodies, is this accepted by all of them? This might be of interest if you're thinking about filing internationally. So once you've selected it, I went with something different, and I chose candy because I was starting to get hungry as I was filling this out. Candy is in class 30. Once you've selected your goods, you're going to need to choose a filing basis down at the bottom. And the filing basis is 1A for goods you're already using, or 1B for goods that you're intending to use. Again, if you would know if you need to use the 44D or 44E option because you would have a foreign registration or foreign application that you were using as the basis of it. So if you're not sure what those mean, you don't need to use them. But the 1A means I can take a picture of it right now. I've got a package. And 1B means I don't have it yet, but I will soon. All right. We're going to proceed as though we filed a 1B, and so we won't need to upload a specimen. If you'd chosen a 1A, you'd have another page where you needed to upload a specimen file or files. You can upload more than one, but you need at least one specimen per class of goods and services. And you'd also need to, if you're using a web-based specimen, for example, an advertisement that you have online or your product catalog that's on your website, you'd need to tell us where and when that is. So put the date that you accessed the page and what the URL of the page is. You'd need to include that information. There's a box to put it in. For this demonstration, we've not needed to go that route, and so we find ourselves at the fee information page. Here, I just got the one class, class 30 for my candy that you can see up in the middle, and $225 is the total fee due. Now, as an ITU filer, I will need to submit a filing later on. I'm going to need to either amend it to use or file a statement of use. Either one of those is going to cost an additional fee. At this time, I believe it's $125. But so do bear in mind that filing ITU will incur a fee down the road. That also leads me to one thing that I want to mention, is that a lot of times we will get questions about something in the mail that someone received, or an email, or sometimes a phone call. But typically mailing is an email that people receive that appear to be solicitations from the USPTO requesting more money. USPTO fees, and those of trademarks, are associated with filings. So whenever you pay a fee, it's going to be at the end of making a filing. And there may be occasions where you submitted an insufficient fee earlier, so you'll need to submit the remainder of the fee, but that will always be a very clear communication from the USPTO. There won't be any question about whether this is actually the government, because we'll talk to you and we will never ask for your personal information. So here, you're going to, oops, sorry, I skipped ahead. It's not really much of a spoiler because it's not that exciting. But after you review whether you have the right fees and classes, you're going to move down to the signature section. Now, there is a little bit of a difference in trademark signature standards versus patent. We don't accept PDF signatures or electronic signature software. We don't accept those kinds of signatures. So there's only 3 ways to sign. One, you can sign on the form by putting your signature, an alphanumeric signature, between 2 slashes. That just simply lets us know that you understand that as a signature, and it's just going to be formatted the way it is on the screen. After you provide your name and owner information, you would validate in this case, and this is called a direct e-signature. We also have another option, though. If you are not going to be signing directly, there are 2 options. For example, you may have other parties who need to sign a filing. Now, on an initial application, if you were, for example, a co-inventor with several others, but you want to sign it directly, you're actually able to sign the application on behalf of the other inventors just by signing it multiple times for however many owners you've put in, but just with your name, not with their name. It's presumed that when you sign, you have their permission to do so, that you are authorized to do so. The signature requirement changes if you're signing a response. Or for other documents after the application, they may require everybody to sign individually. In that case, you might choose option 2 here, email text form, the second radio button, email text form to second party for signature. This will essentially email a link to someone else so that they can open up the signature page of this application, sign it, and then close it and return it to you. They won't be able to make any other changes, but they will be able to sign and return it to you for completion and submission. And finally, we have a handwritten pen and ink signature. The pen and ink signature must be completed in the traditional analog fashion, but then it would be scanned and uploaded as a JPEG or as a PDF. So that would be the third option. And this signature, when you use the handwritten pen and ink signature option, must be accompanied by the declaration that you can see at the bottom of this page and the top of the next one. There are certain statements that you must aver to as being true before the application will be accepted. So if you are, for some reason, inclined to file the pen and ink signature, please make sure that the declaration in the yellow box at the end of this page and at the beginning of this page is included. Once you signed, you'll have the opportunity to validate. Now, the validation does not submit the form. However, it will take you to a review page, and this is the page from which you will submit the form. You can click the input link up at the top under the green application data bar. When you click that input link, it's going to open up an input table. This will look like the filing receipt that you get via email once you've completed it. Please know that the input table at this validation stage is not considered final. The only thing that we would consider final and evidence that you have actually filed an application would be the filing receipt when you present that. So if you have any questions, did I file or not, you need to have a filing receipt. Now, if you believe you filed but you never received your filing receipt via email, we can investigate that for you. But please don't get confused, as we sometimes get questions about between the input table and the actual filing receipt that will be emailed to you. They do look very similar. And finally, this page is where you will save the form. If you are not ready to submit it right away, you can save as that .obj file that we mentioned earlier, save it to your computer, and then upload it later when you come and open up the same kind of form. So if you open up an initial application form, you'll be able to load that file. If you open up a different kind of form, the file will probably not load correctly. If you are ready, you can also pay and submit from here. And this will take you away from the T's page and into the fee payment system. When you finish the payment, you will get your filing receipt and you will be done. So I'm sure everybody remembers everything word for word that I just said, and it's no big deal to file. So I guess we can wrap it up now. We will keep going and cover a few of these issues in a little more detail, just some of the common things that people can trip over. But before we do that, I just want to put this slide in here. I believe these will be available to you after Invention-Con. But some of the links that will give background information and recap things that I've talked about. We have Trademark Basics page, a page all about the initial applications. We have a video series if you're video inclined, the T's, Nuts, and Bolts series. And we also have a trademark video library with additional trademark videos. All of these are good resources to review, especially before you begin applying. Now, it may happen that you get, once you file, it's accepted, you'll probably have about 3 months where the status changes online, but nothing, with regard to the actual prosecution of the application happens until it's assigned to an examiner. When it's assigned to an examiner, you may get an office action after the examiner reviews it. And the office action may refuse the mark or say there are additional requirements that need to be met before we can accept it, or both. When you get this email, you can click on the circled link in the image, and that will take you to TSDR so that you can view the office action. Or you can go, if occasionally the links do not work, oftentimes due to email security settings. So you can also go to tsdr.uspto.gov and put your serial number directly in and look for the office action that was sent on the same date indicated in the email. You'll be able to read it there too. Make sure I didn't, here we go. When you respond to office actions, just make sure you're using the right form. After the initial application, you'll want to use the response to office action. That will be in response to a non-final office action. Now, once you respond to an office action, if you are unable to meet the requirements or refusals or to overcome the refusals that were issued by the attorney, you may get a final office action that will tell you the issues that still remain with your application. At this point, you want to use the request for reconsideration after final action form. Final office action, I'm sorry, that should say. So there are two different forms. Just please make sure you're using the correct one, depending on the office action you're applying to. If it's a non-final, use the response to office action form. If it's a final refusal, then use it's called the RFR, or the request for reconsideration form. And please note that the response signature requirements are somewhat more restrictive than they are for an application. So they have to be signed by a proper party, someone who has authority to make a change to the application. If you are not represented by an attorney, then you can sign it. If you have chosen to be represented by an attorney, the attorney must sign. The trademark office will only do business with one party at a time. And if attorney of record is present, we will do business with the attorney of record. You can click that link also to view more detailed information about the response signature requirements. As thrilling as I think it is personally, it may be a little dry to spend too much more time on. So we'll go ahead and move on to the response wizard. Now, this response wizard is what will show up when you start a response to office action form. There may be fewer than 10 items, but it has up to 10 that will determine what you can do in the response. And there is the last option on the page, often option 10, but sometimes 8 or 9, depending on what you're filing, will force a declaration to be included in this. So if you've been told that you need to submit a declaration and you're not sure where it is or don't feel like you've been able to sign it, you can come back to the form wizard, choose option 10, and it will make a declaration appear. So let's take a look and go through sort of a 30,000-foot view of these issues here. We obviously won't be able to discuss them all with the time we have, but in the form wizard, option number 1 deals primarily with refusals. These are statutory refusals, but essentially it means that there is something wrong with the trademark that is not just a formality or something that we can adjust easily. There's something that is a statutory basis for refusal that's written into the Trademark Act, and it needs to be overcome before the mark can proceed. So some of the ones you may be familiar with are the first bullet, is it likely to cause confusion with another mark? This is the 2D likelihood of confusion refusal. Or the second bullet, is it merely descriptive or generic? Or also deceptively misdescriptive. The descriptive and generic refusals are the section 2E1 refusals. So when you hear those terms, these are the top line refusals that they're referring to. You can overcome a refusal. It's definitely not a death sentence for your application, but the formality required is often significantly higher and requires more evidence. Option 2 deals primarily with requirements. These are things that are required as part of the application, but can often be changed by an examiner's amendment, or are just essentially there was a good faith attempt to apply with a requirement, but it did not meet the specificity that we need, so we need additional specificity. So option 2 deals more with requirements than with refusals. Option 3 here will populate that long section of the form that I talked about several slides ago that you need to make sure that you fill out when you're doing a TEAS Plus application if any of them apply to you. It's the additional statements section of the form, and it includes those things. Again, they're not all specific to TEAS Plus, but many of them are required to address if you are filing TEAS Plus. One of them that's not a required element if you're filing via TEAS Plus is a disclaimer. A disclaimer is essentially an acknowledgement that certain wording in the mark that you're trying to use is in fact widely used in the industry and cannot be reserved for your exclusive use with regard to these goods and services. So you are claiming no right to use that particular wording. You're only using it in the context of your whole mark. But again, the color claim, mark description, prior registrations, translation, transliteration, these are all in there. So this option 3 will get you the additional statement section of the form if there's anything in there that you may have wanted to fill out in the first place but had not. Option 4 is to submit a new drawing of the mark, but this is really only for a better quality image in most cases. Certain changes to the mark are permitted, but they will be outlined by the attorney and you'll need to discuss it with them. It's very case-by-case specific. So generally, the only time you're going to use this is for some reason the mark image that you submitted, some of the wording was illegible or something happened to it and we just need a different version, a clearer version for our records. Oops. It's that 5-second lag, just the right amount of lag to fool you. So for number 5, these are for certain changes you need to make in the records, and you can do this through in the response form, or there's another standalone form that you can use if all you need to do is this called the change of address or representation form. But this is essentially where you'll update the records and the attorney's information, if any. Number 6 adds goods and services, classes of goods and services to the application. You can't add them at will. You can't just say, you know what, I forgot to mention that in addition to the power sander that I'm making, I am also making medical supplies. If it's not in the initial application, you can't add it here. However, if it was in the initial application but misclassified, you may need to add that class and pay the fee. So this is where you would do it. There are additional fees you can pay in option 7 that I think are fairly straightforward. And option 8 is when an attorney is appearing for the first time in the record. 9 lets you update your email address. That's primarily what that is used for. And 10 is the aforementioned signed declaration option. If you have been told in the office action that you omitted a required signed declaration, and you go through and you find that you haven't been able to submit it, generally the form will automatically populate a declaration when one is required. But if for some reason it does not, you can choose option 10 to manually override that decision by the form. So these are the 10 wizard questions and the broad categories of things that they contain. I want to talk about intent to use forms briefly. We touched upon them. We have an amendment to alleged use, and a lot of times if you've had a mark that's been refused on grounds of descriptiveness, but you've started using the mark, you may amend to alleged use, which means this mark has descriptive wording in it, and I acknowledge that. I want to amend it to the supplemental register, but because I'm not eligible for the supplemental register until I'm using it in the mark, I need to amend it to alleged use first. So we may often see an AAU, or an amendment to alleged use, when someone's received a descriptiveness refusal, but they've also started using the mark in commerce in the meantime. The statement of use is an intent to use form that is used after the mark in an ITU application has been published for at least 30 days for potential opposition. Once that period is over and the mark has not been opposed, a notice of allowance will issue and the statement of use will be due. You'll have 6 months from this NOA date to show use in commerce. If you can't show it within 6 months, you may get to the next item, the request for extension of time to file an SOU. So you can file extension requests every 6 months from the NOA date for a total of 5 extensions of time. So you can get essentially 3.5 years to show use, or sorry, you can get, yes, 3.5 from start to finish. So you can get a pretty good period of time to show use, but you will need to show it eventually. And of course, all of these do have fees associated with them. Again, we are a filing fee agency, and the fees that we charge need to be somewhat in line, at least, with the processing costs of the forms and filings that you're making. So these all have affiliated processing and filing costs with them. You can also change correspondence information or change attorney, these forms do not have any fees associated with them. These are record update fees, and it's in everyone's best interests to make sure that everyone's records are updated, and that's does not require extensive review for the most part anyway. The one thing I do want to point out here, I think it's actually on a later slide, but the withdrawal of attorney form would be used by the attorney. It's not used for you to withdraw your attorney. This is for the attorneys withdrawing themselves for various reasons. You would revoke or appoint an attorney if you've hired one. And finally, there's some post-registration forms to review. After you have succeeded in getting your registration, your time with the trademark office is not at an end. I know you'll all be happy to hear that. You'll be able to amend the registration by filing a Section 7 if there's some sort of mistake in the registration certificate. You'll be filing a declaration of use periodically. And so the first time you file it is after between the 5th and 6th year after registration, and then each 10-year interval. So you'll file it between year 5 and 6, then at year 10, at year 20, and year 30, etc. As long as you're still using the mark, you can keep your trademark registration active. That's one of the differences between the patent and trademark side, is that the term is use dependent, and as long as you are using the mark, you can keep it registered. We have marks that have been used for over 100 years that are still registered. The Section 9 application for renewal is every 10 years from registration, and it's typically combined with the Section 8. And finally, the Section 15 is the Declaration of Incontestability. Essentially, that means people may still contest your mark up to 5 years after it registers. If you file the Declaration of Incontestability, they essentially can't. Someone could say, well, this mark is descriptive. A few years after you register, it may go to one of a number of different bodies and maybe determine that the mark is in fact descriptive and should not have registered, so it could be canceled on those grounds. But once you file a Declaration of Incontestability, that's it. You have a high level of protection. If the mark has become generic, there still may be issues, but generally other parties are not going to be able to come in and start a cancellation proceeding after this Declaration of Incontestability. A few last areas. We talked about attorney representation earlier. Again, if you are an individual who is represented by an attorney, we won't correspond directly with you. You have to revoke that attorney first. Don't use the withdrawal form. Please make sure to use the revocation of attorney form. Otherwise, the USPTO will only communicate with the attorney. Attorney representation does end at a few different stages, so please be aware of those. The attorney information will remain in the record, but they will not necessarily be considered the attorney of record. And finally, again, foreign domiciled parties have to use a U.S. licensed attorney. One of the other areas, again, that I want to recap is changing the owner information. Minor typos are okay, but you need to assign the mark to a different party. You can't just change the owner. If you made a mistake, it may be a curable mistake. In some cases, it won't be curable, and the mark will be void ab initio, from the beginning. Generally, ownership must change through assignation. The assignment should generally be recorded for clarity and ease of proving the chain of title. However, it's not always required. But generally, filing an assignment with us is the surest way to make sure that our records will stay up to date and that no unnecessary actions will issue with regard to this mark. So you can find other trademark updates and alerts at the websites below here. I do advise to subscribe to trademark email alerts. Generally, pretty high profile and important announcements go out that way, and we don't send that many. And you can also look at the TEAS maintenance and release schedule online. For example, it would tell you if you looked, we are expecting to have a planned outage this weekend on Saturday and Sunday for some major changes that are being made, or major updates that are being made to TEAS. So that will tell you when you can expect the system to be up. Generally, it's going to be up except during the overnight time specified, but this weekend it will be closed. And that's all I have for right now. I think we're ready for any questions, if anyone has any. And if anyone wants me to go back over something that I covered too quickly, please feel free to ask that too.
Thank you, Matthew. I do have some questions for you, so whenever you're ready, I'll go ahead and start.
All right,
If you could also put the information from your last slide so that we can see the contact information, just to keep as a reference. And in the meantime, I'll start with our first question. What happens if I miss a filing deadline?
So, it depends. If you're during the application process and you miss a filing deadline, you'll have an opportunity to file a petition to revive. So you'll be able to bring the application back to life. There's certain restrictions on it. You have to be, within 2 months of the time you found out, or within 6 months of the time it abandoned. But you can file the petition. There's a petition fee affiliated with it, and you can resume the application. There might be a few limitations with that. If there was an intervening filer, for instance, there could be a delay to your application. If someone filed a very similar application to yours while yours was dead, that might add significant time and complexity into the process. But generally, if you inadvertently abandon an application, you can revive it. Now, registrations are different. Registrations under very limited circumstances can be reinstated, but almost always a registration that's canceled for failure to file maintenance documents for whatever reason cannot be revived. So please make sure your email is up to date. Please make sure you're checking in during the required timelines. You can go to TSDR and see an upcoming filing options for your registration. And that would tell you, well, your Section 8 and 9 is due in 2 years. So if you ever have any questions about it, you can easily go and look that up, and it will tell you when the next filings are due. If those filings are missed, registration is canceled, typically cannot be reinstated, and you'd have to start the application process all over again.
Okay. The next question I have for you is, what does USPTO do to protect my trademark?
So the USPTO, I'll start by saying what the USPTO does not do. We're not an enforcement agency, so we can't go out and bring someone into court on your behalf. So the primary protection is the notice provided to the public by the registration. Now, when you get a registration, I mentioned briefly before, you could have a supplemental registration or a registration on the principal register. Supplemental registers for marks that aren't inherently distinctive, but maybe they could gain distinctiveness. So something like, Apple computers, for instance, is inherently distinctive, right? What's the connection between Apple and computers? It's not clear. If you had a company that was named, General Information Systems or something, that's definitely not on its face a mark that you could easily separate out from other companies doing similar things, but maybe it could become distinctive. So that would be on the supplemental register. Marks that are on the principal register get many valuable presumptions in court. There's a lot that you do not have to prove with evidence regarding your ownership of the mark or its distinctiveness or the scope of its use or the time over which it's been used. So those are some of the primary protections that you get. You also get on the principal register border enforcement. So imports can be stopped if they are infringing on your mark. So those are typically some of the biggest advantages. In addition to the public notice system, your ability to use the circle R to let people know that your mark has been registered, and that essentially it's really not going to be worth your time to try and infringe because it will be significantly easier to prevail in court with the rights afforded by registration.
Thank you. The next question I have is it true your work is protected in some ways as soon as you place it on a media platform?
To me, that sounds like it might be coming from someone who's familiar with copyright. And so trademark is a little bit different. You do not need a registration to have trademark protection, which is where I think that's coming from. And that is true. When you start to use a trademark, you will gain common law protection. The trouble with not having a registration is you have to keep every document and hire an attorney to prove, in many cases, use in a certain area during a certain time, and the scope of your trademark will be limited only to what you can prove. And it's also very difficult to, it's not impossible, but if you were, for instance, in a dispute with someone who had a registration and they have those presumptions, it can be an uphill battle. So the primary, yes, you can, there are some people, and, I don't get paid per application or registration, so I can say this. Not everyone will need to file a trademark. Someone who has a very limited use, someone who doesn't care if somebody else infringes their mark, and some people don't. Someone who is not prepared to spend what could be, some significant money to defend the mark. In all of those cases, someone may reasonably make the decision not to file a registration. However, because trademark registration prices compared to other business expenses are relatively low, and they do offer so much automatic protection, I generally, would encourage someone to go for the registration as soon as they think they're able to. Federal registration is a very strong tool to have in your pocket.
Okay. Well, thank you, Matt. That's all we have time for today. We do have some other questions I'll be sending you, and we will get answers to those questions if you email those in and get back to you. Thank you again, Matt. And that concludes our first day of Invention-Con. Join us again tomorrow as we start at 12 o'clock Eastern Time, going until 5 p.m. Eastern Time. We're focusing tomorrow on businesses. So tomorrow we'll be covering our government resource panel, talking about services available to independent inventors and small business owners. We're going to talk about building your business model, helping you prepare for building the business you need and planning for the items that you need to be successful. Building a virtual business, talking about the importance of today's market, being at home and working from home, how that can benefit you in building your business together. And our keynote speaker, Sam Zaid, CEO and founder of GetAround, will be speaking at 4:15 p.m. We look forward to seeing you tomorrow, and thank you for joining us today. If you have any questions related to the program, you can email us at inventioncon@uspto.gov, and we'll be providing you with an email with a survey on the end of the program on Saturday. So if you have any comments, concerns, or ideas that we can look forward to in the future, please be sure to submit those in the survey. Thank you, and have a great day.